Can we fix Senator Carter's name, please, before we go live, especially? All right, excellent. I think we see Mr. Lancaster here. All right, so again, I'll just make another announcement that we're not. So we're just going to finish up the LEOBR, which we have I think 3 or 4 pages to go over tonight. Tomorrow, no work group session. We're just going to make sure you get your amendments in for our voting session, which will happen on Thursday and Friday. And again, just announce, after the bill drop deadline, we actually didn't receive as many bills as we previously anticipated. So our schedule will lighten up considerably in the next week and a half. So once we get over this hump, we'll have fewer bills on the docket each day. And I think we have 1 day of no bill hearing. So schedule will lighten up. I know we've been pressing really hard. And so I really appreciate everyone's work and dedication. And I know we're pulling double, triple overtime. So with that, we'll be very quick tonight. We'll be under an hour. And I'll give you a chance to kind of review the material. I know that everyone has probably received the FOP amendment package to the LEOBR. So look at that tonight and tomorrow. That should have been sent to your staff. And so with that, Jamie, we'll go through methodically but quickly for the last couple pages, and then we'll call it a night. And just a foot stomp again, make sure you get your amendments in by COB tomorrow, so that they're ready for our voting session on Thursday and Friday. And we'll send out another agenda just to make sure everyone's clear. Jamie, you're up.
Thank you, Mr. Chairman. So we left off on page 11. This is around line 9 on down. This part of the bill just lays out the procedures and requirements for the hearing. So just running through quickly, the hearing officer needs to allow ample opportunity for the law enforcement officer and law enforcement agency to present evidence and to make arguments during the hearing. The officer may have the assistance of a representative at the hearing. Evidence with probative value, and feel free to cut me off at any point. Evidence with probative value that is accepted by reasonable and prudent individuals in the conduct of their affairs is admissible. Privileges that are recognized by the courts in the state are recognized in this hearing. It prohibits incompetent, irrelevant, immaterial, and unduly repetitious evidence. Subject to a determination of admissibility by the hearing officer, each record or document shall be admitted and made part of the hearing record. The documentary evidence may be received in a form of copies or excerpts, and the hearing officer may take notice of judicially cognizable facts, general, technical, or scientific facts within the hearing officer's specialized knowledge. The hearing officer is required to notify each party of the facts noticed by the hearing officer either before or during the hearing, or by reference in preliminary reports or otherwise, and also to give each party an opportunity and reasonable time to contest the facts noticed by the hearing officer. The hearing officer can rely on his or her experience, technical competence, and specialized knowledge in the evaluation of the evidence presented by the parties. And the chief or the hearing officer may administer oaths during a hearing. There's a provision for witness fees, mileage, and expenses that are necessarily incurred for securing the attendance of witnesses to be paid by the law enforcement agency. The official record, including testimony and exhibits, needs to be maintained by the law enforcement agency. And then after the hearing is concluded, the hearing officer prepares written proposed findings of fact. From that point, the hearing officer provides those to the law enforcement officer and the chief. And then within 60 days after receiving those, the chief has to review them and determine the appropriate discipline, if any, imposed against the law enforcement officer. This also has to come with a written decision, including a summary of the facts and evidence the law enforcement officer committed the offense or offenses and is subject to disciplinary action and why the discipline is appropriate. So that comes from the chief. Turning into page 13, this is the limitations period that a disciplinary action needs to be brought within. So a law enforcement officer may not be subject to a disciplinary action under this subtitle for an offense unless the chief or the chief's designee provides notice to the law enforcement officer within 1 year after the law enforcement agency becomes aware of the act that gave rise to the disciplinary action. So it's providing notice of the disciplinary action. The exception to that is in lines 8 through 16. So a disciplinary action can be brought at any time for an offense relating to criminal conduct or the use of excessive force. And for an offense that was the subject of a civil suit within 1 year after final disposition in the civil suit, or if the investigation reasonably required more than 1 year to investigate, the disciplinary action would be required to be brought, or that notice would be required promptly after the investigation is completed. So moving on down, line 17 on page 13 into page 14. So this is section 3108. This provides for the suspension of a law enforcement officer with pay on an emergency basis. A chief is able to suspend a law enforcement officer with pay on an emergency basis if the suspension appears to be in the best interest of the public and the law enforcement agency. Now, the chief or the chief's designee may suspend the police powers of the law enforcement officer and reassign the law enforcement officer to restricted duties pending a determination of either determination by a court as to the law enforcement officer's guilt in a criminal proceeding, or by the chief as to the disciplinary action to be imposed against the law enforcement officer. So that pertains to suspension with pay. In page 14 at the top of the page, so lines 1 through 7, we touched on this yesterday in a discussion. So the chief or the chief's designee is able to suspend a law enforcement officer without pay and suspend the law enforcement officer's police powers on an emergency basis if the officer is charged with a crime. And of course, in both instances, if the law enforcement officer is suspended, they are entitled to prompt completion of the disciplinary proceedings. The next section down, which is 3109, that's lines 8 through 16 on page 14, relates to adverse material in the file of the law enforcement officer. It prohibits a law enforcement agency from inserting adverse material into the file of the law enforcement officer, except a file pertaining to the internal investigation or intelligence division, unless the law enforcement officer has an opportunity to review, sign, receive a copy of, and comment in writing on the adverse material. The exception to that is if the law enforcement officer waives that process. In 3110,
Jamie, just real quick, I know Senator Sidnor has a question, and then Senator Hettleman.
Thank you. Just out of curiosity, because I don't remember from testimony, but the purpose of 3109A, I mean, has there been an issue where adverse material was being placed in file of officers?
I'm not specifically aware, Senator. I'll have to double check on this, but that may have actually come from the existing LEOBR, or maybe paraphrased from it. But I couldn't say with 100% certainty right now, so I'd need to get back to you.
No worries. Thank you.
My question actually was along the same lines, was where did that come from, and what experience has there been along those lines?
Right. I haven't heard anything specifically related to that. My gut tells me it probably is in the existing LEOBR, but like I said, I'll need to. Senator Carter's got a thumbs up there.
It is. So why? I guess my question is why are we keeping it? Why are we keeping that in there?
I don't know
if Senator Carter can respond to that.
There you go.
I don't feel strongly about it, but I mean, I didn't necessarily have a problem with it. We don't want to have adverse material that hasn't led to any conclusion necessarily in the file.
I guess I need to know what that means exactly. I mean, if it's something about some random act that happened not related to the incident at hand, I get it, totally. But if it's unclear to me what it is really meaning.
I think you make a point. I think it could be, it's very broad and very general. Maybe we could specify what that should entail. You're good point, but it does come from the original LEOBR.
And just to clarify, what that provision says is it doesn't apply to a file pertaining to the internal investigation or intelligence division of the agency. So the internal intelligence division would, or an internal investigation division would be conducting the investigation into misconduct. But what that seems to be saying is that if there is adverse material other than that, the officer needs an opportunity to review and sign and get a copy of what that material is.
I guess but isn't that covered in a different provision?
I'm not one that we've already gone through, or no, I don't think it specifically is, but is there something that I'm happy to take a look and see if there's a someplace else that would fit.
Okay, I'll look too. Thank you.
Senator West, go ahead. You can just chime in. Go ahead, Senator West.
So I guess my concern is we have this other bill, a Public Information Act. And so I certainly, they used to say about the FBI files that they contain everything that came in over the transom, all the flotsam and jetsam. And I would not want a law enforcement officer's file. There's a distinction between his file or her file on the one hand and the file of the investigation on the other. I would not want an officer's file to be filled with flotsam and jetsam if it's going to be subject to public viewing. I just don't think that's fair. So maybe, I don't know whether we amend the other bill to deal with this or we amend this bill to deal with this, but we need to do what's fair.
I think so. For the other bill, and Jamie, correct me if I'm wrong, for the MPIA, I mean, that deals purely with discipline, not just like all matter of like promotional records and whatever else may be encompassed in a personnel file, admin notes and so forth. I think it's just purely disciplinary matters for the MPIA bill.
So, Mr. Chairman, yeah, that's generally right on. It's the way that the other bill functions is that it actually excludes certain material as being considered part of the personnel record. So for the purposes of MPIA, personnel records are generally not subject to disclosure, they can't be disclosed. So what that bill is doing is actually saying that those specific files actually don't constitute the personnel record pertaining to discipline. So,
All right.
oh, sorry.
I think I get it.
So moving on down in page 14, starting with line 17, provides that if the law enforcement officer is placed on leave without pay when the officer is absent without approval, it doesn't constitute a, placing a law enforcement officer on leave without pay when they're absent without approval is not a disciplinary action within the meaning of the subtitle. So they wouldn't be entitled to the process and procedures if in order to place them on leave without pay. A law enforcement officer who is placed on leave without pay for an unapproved absence may also be subject to disciplinary action for the unapproved absence. So if some other recourse was sought in that instance, then they would need to go through the process that's laid out in the bill. Requiring a law enforcement officer to make restitution for loss or damage to the law enforcement agency's property due to the officer's negligence is also not a disciplinary action. Law enforcement agency may not require a law enforcement officer to pay restitution exceeding 3% of the officer's annual base pay. Law enforcement officer who is ordered to make restitution may also be subject to disciplinary action, civil prosecution, or criminal prosecution under state law. So moving on to page 15, this provides that the subtitle doesn't preclude the chief and a law enforcement officer from agreeing to holding in abeyance a disciplinary proceeding or action for a period that doesn't exceed 18 months in order to allow the law enforcement officer to improve conduct or performance. It also doesn't prohibit the agreement of imposing a lesser disciplinary action.
Sorry to interject, Jamie. Sorry, Senator. Sorry about that.
Sorry, Jamie.
Stay unmuted though, please, Jamie.
Sure.
Sorry, I have a question about 14, line 28. When it says they may not require law to pay restitution exceeding 3%, and then it says that they can still be subject to civil prosecution. If a judge finds them, what happens? Does the judge have to stay within that 3%? I'm just.
So that would be restitution imposed by the law enforcement agency. I think the court would be subject to other state law regarding restitution. As far as a fine, that would be part of the sentence that was imposed in a criminal prosecution. So what that provision in line 33 is saying is that the criminal prosecution can proceed.
Right, but would there ever be a time where line 33 would conflict with line 29 or no?
I don't imagine it would, at least not in the context of in the context of the criminal prosecution, because the restitution in lines 28 through 30 is what's being required by the law enforcement agency. So the agency as the employer is saying that they're going to require the officer to pay.
One's agency and one is the court. Okay, got it. Yep, thanks.
Senator Jackson, go ahead.
Yeah, thank you, Mr. Chairman. And Jamie, just for Senator Hellerman. So if I were to wreck my vehicle due to negligence, or run off the road and actually damage some property, or God forbid hit a civilian. I mean, there are these things cross, but there's also a disciplinary action that's taken within the agency, and so that officer would be, or I would be required to pay to replace that equipment or a percentage of that. So that's how that reads. A little convoluted, but that's what it's meant to do.
So just to follow up on that, Senator, actually, I think this is under the existing LEOBR.
Yes.
So you're probably familiar with it through that context, but I guess you read that to mean that the restitution is one aspect of it, but through that disciplinary process, that repayment or a form of restitution could also be required in the disciplinary proceeding.
Yes.
So going on to, or back to page 15, the law enforcement agency and the officer can also agree to imposing a lesser disciplinary action as final and binding, not subject to further review. It also provides that if the officer fails to appeal in accordance with the subtitle, the officer is considered to have accepted the decision. A failure to decide an appeal in accordance with the subtitle is considered a denial from which is considered a denial from which an appeal may be made. And the parties may agree to waive or extend any time stated in the subtitle. So the time requirements are subject to agreement. So moving down at the bottom of page 15, this provides for the appeal rights within the agency. So if the disciplinary action is imposed by the chief's designee, the officer or the officer's representative can go to the chief at that point with a written appeal of the disciplinary action that identifies the issues of fact and law that the officer believes would warrant rescinding or modifying the disciplinary action. This has to be done within 15 days after the officer receives notice of the chief's action. The chief may confer with the officer before making the decision, and the options that the chief have are to uphold the disciplinary action or rescind or modify the disciplinary action taken and restore the law enforcement officer any lost time, compensation, status, or benefits. The chief is required to issue a written decision that addresses each point raised in the appeal within 15 days after receiving it. Within 15 days after issuance of that decision, within 15 days after issuance of a decision to rescind a disciplinary action, the action shall be expunged from the law enforcement officer's personnel record. So if the chief reverses course on the action, then it ends up getting expunged. Next, lines 10 through 13, a law enforcement officer may appeal a decision made under 3104 through 3106 or 112, which we'd already gone over in the circuit court in accordance with Maryland rules. That is the rule regarding administrative proceedings, I believe, 7202. And at the bottom of the page, so this is lines 14 through 30, a county or a political subdivision of the state may adopt a local law or ordinance to establish an oversight body to adjudicate disciplinary matters and impose disciplinary action for law enforcement officers under the subtitle. If the county or political subdivision does this, then the powers, responsibilities, and procedures that would apply to the chief under this subtitle instead apply to the oversight body. This also provides for the composition of the oversight body. So if one is established, it must be composed of residents of the county or political subdivision, and no member of the oversight body can be a current law enforcement officer. It also provides for allowing access to all necessary records of a law enforcement agency by an oversight body established under this section.
Hey, Jamie, we've got Senator Jackson's got a quick question here.
Sure.
I apologize, Mr. Chairman. I'm trying to on my floor system and then trying to, I don't know how to raise my hand yet, but so I guess to pose a question to Senator Carter. HB 1016 allowed for civilians to sit on trial boards or administrative boards. That's 3 years ago, 4 years ago. And so to change that matter, I mean, obviously agencies have not taken advantage of that the way they should have. So I guess you're gonna, I guess we're getting rid of what 1016 said and to bring in, to insert this, or do we, direct these agencies to have civilians on these boards?
No, thank you, Senator Jackson. I'll try to streamline my comments.
Okay.
And explain the intent and why this is important. So prior to coming to the Senate, I presided over an agency where the Baltimore City Civilian Review Board existed. And my experience there, I had occasion to travel the country to explore what civilian oversight agencies looked like across the country. There's actually like entire organizations dedicated to this work. NACOL is one of them. And they would have, so the point is, in the exploration of these entities, what we found is that there are places that have actual independent boards or bodies, entire agencies resourced, that take all of the discipline out of the police department, and they are resourced, trained, and equipped to stand in the stead of those agencies. Then you have these other agencies entities like you have in Maryland. We only have two, one in Montgomery County and one in Baltimore City. They're, less powerful. They are less resourced, and they just have an ability to review some of the allegations within the disciplinary scheme and make recommendations with no real power or authority. Then you have places that have none. And so the intent here is to allow for a local jurisdiction to create, if they so choose, an independent entity that could feasibly have that complete authority to stand in the stead of the internal disciplinary process. Of course, we are a very long way from that at this time because we don't even have anything close to that in any jurisdiction in Maryland. But I will tell you, like, for example, what could happen, it might be the biggest concern or worst fears of some people, but what ostensibly could happen is that Baltimore City City Council could decide that they don't want to keep the internal disciplinary process within Baltimore Police Department. They want to resource an entire independent body. They could call it the Community Accountability and Oversight Board. And that board could actually stand in the stead of IAD and the chief and make the decisions. And why is it important? It's an important step in moving more toward the potential for community input, community participation, and more than that, even community authority over how their policing disciplinary processes are conducted or over the police. So that's the goal in the language. I understand that it's much different. It's much more extensive than the concept of putting civilians on trial boards, which I've never thought was enough. First of all, under this bill, there wouldn't be a trial board to put them on. But number two, the civilians on trial board was a step in the right direction under the old system. But at the same time, like, it didn't specify that these civilians could vote. There were also civilians that were selected by the chief or by the agency. And so the idea that they were really going to have a great impact was slim to none. Not only that, there were only allowances for 2 civilians out of the 5, like still the 3 trial board members, the police, law enforcement ones, the 2 civilians. So at the end of the day, they really didn't have power under that old system. So my answer is, this was intentional. It's designed to create a possibility of an oversight agency, but currently none exist in Maryland in any jurisdiction, and I would posit that none are close. But I do think that looking toward the future of reimagining policing and civilian oversight, I do think that this is an important step in this bill.
I think so. I appreciate the background. So we're not close in Maryland to doing what you're suggesting in the bill.
Well, it would, so like Prince George's County, or I don't know, you have 3 jurisdictions. So Prince George's County Council or Charles County Council or whatever, which
Calvert.
Calvert, yeah.
They could decide, you know what, we want to have more community input in policing. We want to have more community oversight. We are going to create an entity, resource an entity, which is a big thing. How you doing that?
I got you.
And have trained, certified persons that are equipped to investigate and render disciplinary decisions. It would require that in order to happen.
Well, look, I can tell you that in the circles I've been in my 30 plus years, I mean, there's conversation in the executive level and at the even sparingly at the FOP level of a system sort that's established such as that, and that's what those folks do. That's their job, and so that's there's certainly talk about that. My concern is to take in the bill to go from a 3-member board, which has the capacity to have 2 civilians and a sworn law enforcement officer sitting in an administrative hearing, and to take that away and then to just have 1 person, which is a challenge because, look, nothing happens from a public perspective, the thin blue line or, whatever the terminology is today. Nothing happens in law enforcement that's not known about in law enforcement, period. I don't care what level you are. And so I think that having the chief or the sheriff to be the one that's rendering that decision, I think I just don't think it's a fair piece for the folks that are involved, because they still have an opportunity to assess the findings. I think, and it's interesting for me because I've been, at all levels of this. So it's interesting where there are some chiefs and sheriffs who say they need to have more authority. And then there are some folks on the FOP side, which I used to lead, would say I need more protection. And I guess, there's some semblance of rarity here that I really didn't have a problem instituting these matters, probably because of, having gone through them, as a troop beforehand. But I do have a concern, and I won't belabor this, but I do have a concern with going from a 3-member board where civilians are allowed to be on those boards. And so here's where the chiefs and sheriffs have not stepped in and done what was, I guess, sanctioned or put out there in 2016 through 10/16. They never moved to that point. So now we're going to give the chiefs and sheriffs, and it sounds funny coming from a sheriff, we're going to now say to them, no, we're just going to give you this because you're saying over the last 3 or 4 years, you still can't get to where you need to get. But they never brought in the civilians in the multiple jurisdictions we have across the state on these, these administrative boards. I'm not particularly a fan of that piece of it. So we can continue to discuss it.
I can understand. So it's a relatively big change. It's a big change for
It's a
Maryland.
huge change.
We've talked about trial boards for so long. Again, I've talked about this ad nauseum, but all the way back to 2009, my big thing was to create independent trial boards. And the reason was because of the Black officers claiming that the existing trial boards were discriminatory. But what I like about this process is that, one, it's more streamlined, but two, it allows officers to more directly hold, and public to hold chiefs accountable. You know, one of the biggest issues with our broken system is that there's been a consistent claim on the part of almost everyone that there's no accountability. And so to me, this says, you know what, this is the chief. The chief is responsible for heading the agency. No more excuses. Chief, make a decision and, you know, let the chips fall where they may. And then you have someone to hold accountable. And, you know, in many jurisdictions, as we know, the chiefs are appointed by the executive, whether it be the mayor or the county executive. And so to me, it more simplifies the process. And I don't want to talk too much either, but to be quite honest with you, we've had many county execs and mayors over the years say, you know, yeah, we really need to get to the bottom of this discipline thing, but they haven't been able to like specifically point the finger at the very chief or commissioner that they hired, and in terms of why adequate discipline isn't happening or why discrimination is happening.
Yeah, and again, I don't want to belabor this, and I'll get off this. I promise, Mr. Chairman. But what I'll say is this to that, and I certainly look forward to more about this. So trial boards are open, so public can sit in on the trial boards. Civilian members were supposed to be placed on the trial board, and I would venture to say, having been in these positions, that again, I hope this is a start to reforming law enforcement in our state, in our country, because there's enough to go around at every level. And I know we have to start somewhere. But I think that, you know, sometimes there's an excuse to say that I can't get rid of these officers because of X. There may be some impediments, but that's not the rule. You and I can talk offline about this, or we can continue to talk about this some other time. Sorry, Jameson. Sorry, Mr. Chairman. Thank you.
No, this is great. Actually, so Senator Jackson, let's continue that conversation more. If you want to put some thoughts down on paper for us to further discuss, that'd be great.
Yes, I do.
Okay, so we've got Senator Huff had his hand up, and then we are less than a page away from being done. So Senator Huff and then Senator Jackson.
So yeah, I'm just trying to understand. So as this bill is constructed, then is that the idea is you're gonna get away from totally the trial boards, and you're just gonna end up with having a sheriff, a local sheriff, or I got 11 municipalities alone in my district. So each one of those little chiefs of police up there, or the sheriff in my county, all them, it's just gonna fall straight to them as far as discipline. I mean, I guess there's a couple of things. One, I always liked the trial board because having been in the military, that's how we did it. You had a trial board. You went in front of trial board and you had someone who was basically your rank, you had someone below you, but I never even liked the civilians. I voted for it, and I don't know if anyone's even used it because I never understood the idea of having civilians or somebody who wasn't a police officer. Just like in the military, you have to have somebody that did what you did and understand what you do in order to judge you. And I never understood having somebody who was not a police officer, not trained law enforcement, knowing how they would actually react in that situation, know what the proper protocols are. So I don't know how you take this away from police being the ones that oversee it. And my concern is, quite frankly, in some of the Western Maryland areas, the small towns, the counties, whatever, you get into somebody's pal or somebody's buddy, they don't want to discipline them, or they don't like this guy, they're going to throw him right under the bus. So when your fate is in the hands of just one person, I think you actually have a tendency for more abuse. Some of these people, they are elected and they're going to put in their buddies and their pals,
I agree.
Friends. And quite frankly, that kind of stuff did happen in the past. So that's for the reason that we created this system. So, and if, as far as, mayors in my town, they have complete authority to fire or get rid of chiefs if they don't like them. Complete authority.
One quick thing I want to throw
But I
in.
mean, I'm just gonna say, I mean, with some of our sheriffs and stuff like that, I'm not gonna point out any of them, but the idea to think that politically elected sheriffs wouldn't play political favorites with people they like or don't like and things like that, and that system is gonna be better.
So
I don't know.
two things I want to just throw in for the conversation. The first is that the sheriffs and chiefs already have all this power because they already select the trial board members, including the ones that have civilians. Number two, less than 10% of all disciplinary cases ever make it to a trial board. 90%, or just about, I think it's about 88% is the last stat I saw. 80% of cases either are unfounded, so no discipline, or the officer decides to take the discipline, or there's a plea or a negotiated agreement. There are a myriad of other things that happen. Only a very small modicum of cases ever make it to this thing called a trial board. So I think we're talking about it like every single disciplinary decision is like officer says, I want a trial board. It doesn't happen like that. It's less than 10%.
No, I understand that, but we're talking about whether in the proposal to completely scrap them puts it completely in the hands of a chief or a sheriff, and the idea that there are these ultimate fair arbitrators. I think you have a system that could be as much abuse or more, quite frankly, more. If they're friends or pals with them, why would they want to discipline them? And if they don't like the officer,
Couldn't the same thing be said though in every? Couldn't the same thing be said in every profession? Like, couldn't the same thing be?
No, they see this officer as up and coming. Maybe they're going to come after him and run for sheriff one day. I'd love to cut that guy down. Send him to my office. I'll take care of discipline on him. I mean,
But why is that not the same as what you see in education?
Because it's human nature, and then to diversify it and have more than one person looking over and disciplining it versus putting it in the hands of one person, I just think that's a bad idea. And that's why we got away from this system. This was exactly the reason why the system was created, because officers felt like they were being unfairly punished. And you did bring it up, it was a racial issue then, and that Black police officers felt like they were being punished and targeted heavily for discipline. But I just say that it all comes back to human nature and politics. And I think that at the end of the day, you have to have police judged by people who do that job. It's the same way we do it in the military and anyone else. You have to know the profession. You have to go through the training. You have to know use of force. You have to understand these things. I mean, heck, when we did this bill last time, well, I just I mean, look, last time we did this, we all went down to the Maryland Police Training Commission and sat through simulated shootings, simulated incidents. We didn't do any of that this time. And if you haven't done that, I mean, it's hard to even, put yourselves in their shoes. You can't, but at least I did that a couple times to training and saw, a little bit of what they went through. But
Some of us did do it this summer.
I've done it before too.
Well, good, glad. I've done it twice. So I would just say, just completely throw out the system. I think it's bad. And you got to remember too, it's much different. You're talking about Baltimore City compared to Western Maryland. You know how many police forces we have in Western Maryland?
What's the point though on that? I mean,
the point is to revert to every little local chief, every local mayor, every local sheriff. The idea that all these people are going to be completely honest brokers. I mean, it's not practical. It's not practical. It's not a practical system.
It works pretty much in our system of education where if there's a teacher that is accused of something, they generally.
Oh, my God, teachers have so many union protections. Tell me, let me bring out a bill on the floor.
You don't think that the
protections and
police
remove the
have
unions.
strong union protections?
Yeah, and you don't think the teachers do? Let me pull this bill out right now.
What I'm saying though, so my point is,
union protections.
I would
See what
posit
happens.
that the teachers don't have stronger union protections than the police.
They have a lot of union protections.
We'll just match.
You're
Let's
up.
just match police and teachers. How about if we just match police and teachers and call it a day? Would you agree with that one? No way, because you can't get rid of a bad teacher any more than you can get rid of a heart attack. So anyway, just moving.
I don't think that's true. I've seen a lot of teachers go that aren't even really all bad.
I've seen them just quit out of disgust, but I haven't seen them be fired. So when we look at this, I get concerned on the whole due process piece of this, because due process is the process that's due. And if you want to give me a ticket for running a speed camera, that gets looked at by one officer. It gets photographed by the machine, but then a cop reviews it to say, yes, there's a violation.
Then it goes to the court. And the court, I can challenge this in court. And if I go to court, I'm before a judge who was appointed by the governor. And that judge also passed the bar exam. They have passed all the character stuff for a bar exam. They have to file their annual disclosure statements. They're governed by a very rigid code that will eject them for inappropriate thoughts, belief, conduct, etc. They're reviewed constantly. They have to be reappointed every 15 years. They're subject to appeal to the court, to the circuit court, and maybe up to even to the Court of Appeals. Everything is recorded. It's they have to know the law. It's this very elaborate process. And that was for a $200 ticket for running a red light. You get all that process. Now we're looking at a cop who's put in 15, 20 years of their life in training and heartache, not just them, but their family. I mean, they put in all of this, and we're suggesting, well, let's cut the process down. We got to be fair, and we can't. Civilians is fine, but honestly, that's like saying, how about we're just going to try you tomorrow in front of some guy that we just kind of volunteered out of the testing tent over here. He looks like a nice guy. We've got to protect these guys' careers. There's substantial investments. And I think what Senator Huff was referring to is sometimes chiefs do go rogue. Sometimes sheriffs do go rogue. So it's got to be a fair process. And I don't want to go out of the frying pan into the fire. I'm one of the folks that says the current system is broken. I don't think it is. It's not providing the level of candor, of oversight, of integrity that the public deserves. I'm totally with you on that, Senator Carter. I don't dispute that at all. But we can't go from one extreme to the other. We got to slide into the middle ground here, because as much as we want to get rid of bad cops, we also want to keep good cops, and we want to be fair to people. We want to be reasonable here. I think it's finding that middle ground that we really got to strive for, that provides a system. And so I'm looking at this, really trying to not jump to one side or the other, because I totally agree with I think your premise that the public has lost confidence, and they lost confidence rightly, because the system didn't allow confidence in the system. So we've got to have a system that allows but when we do that, we just got to be careful. Let's not go out of the frying, let's not go from this whipsaw thing, back and forth. I think we need to really try to be intellectually honest about this and say, what is somebody who's got 20 years of their life invested in something, their pension, all their training, and now you're going to say, well, you're no longer a cop, so good luck, go take the real estate exam or something like that. Good luck to you, and try to start up a new life. It's really, that's tough stuff. So I just want to look for fairness in here. Thank you.
Thank you. I don't want to belabor this, and I won't. I'll just say that the only thing, and I understand, but I've always believed, I believed years ago, and I believe today, that the more fair we make the process, the more we make the process amenable to weeding out bad cops, that actually really helps the good cops. And you and I are both in two professions where, we often come under scrutiny, the profession of law and the profession of being a politician, a legislator, where there's often a great deal of public scrutiny, and a few bad apples make us all look bad. But I don't see us fighting for changing the attorney grievance process to get out the bad lawyers, or even, we want to make improvements even to our own process, electoral politics, to make sure that there's integrity in the profession. Like you and I know this. We want integrity in our profession. We don't want to be viewed as scumbag politicians, scumbag lawyers. And so the more that I'm happy with whatever we can do to weed out the real scoundrels in both of these professions.
I'm with you, but so I'm on Maryland Rules. I'm the Senate's appointed to the Maryland Rules Committee, and we just finished reviewing the lawyers, the process by which you throw bad lawyers out. And I can tell you, I have no patience at all for these guys who deserve to be put out. But I also push back hard, because some of the things they were trying to do, I thought were grossly unfair, even for lawyers, and we're hard to love. But I pushed back. I sort of led the crew in pushing back and saying, wait a second, you're going to many rules. I was just the more vocal spokesman saying, people deserve a chance. You got to give them that fair process. You can't just run roughshod over people, and you get folks in there who just want to say, boom, expedited. And we reviewed the judges' rules as well, and we modified the judges' rules because the judges felt unfairly run upon, and there was a number of significant cases involving female judges who felt they were being totally just smushed aside. And we changed those rules, and we actually, I think we ended up with a better rules for the lawyers because I pushed back hard that I want to change the rules so they're better at getting bad lawyers out, but they also got to be fair to everybody. And I think we're really doing the same process for the cops. So I just think it's so important that we don't do the whipsaw. We got to find the good middle ground and don't look. I know you want to send a strong signal to the public. I understand that. You want to send a strong signal to the public that says, we've changed. But you can't sacrifice people's constitutional rights to due process in order to tell the public we've changed. We're going to have to find the right middle ground and then tell the public, all of us, why it's the right middle ground and that it will make a difference. And we shouldn't seek to make the public's point that we found a new process by making it so outrageous that even the most extreme folks are going to say, oh yeah, now it's a good process. We can't do it that way.
I would just say that there still is process here. There still is due process. I don't agree that this is in any way, this bill.
There's a lot in this bill I like.
Anyone's constitutional rights. And then also, I also want to make it clear that I don't think that chiefs and sheriffs are running around trying to get rid of good officers. Like they want to keep them. They want to get rid of the bad ones. And even that, there's probably some hesitation because it's an arduous process to do so. And they have to be right. If not, they're going to be dragged out in litigation and they can be overturned in a court. So it's not like there isn't process here, but I'm not going to keep this meeting. We can talk more offline. We can debate, we can argue, but we're probably not going to agree because I don't believe that a trial board is a necessity to ensure fair due process for officers in disciplinary schemes. I don't believe that. And I think that you're saying that you do.
I do, only because having been through it many times in the military and seen the value of it.
Military ones, though, have been effective.
The military effective.
They get the bad people out quickly.
And they do, but this one would be effective too if
We're also trying to demilitarize the police too.
If the decision actually lies with I mean, look, the biggest problem we have is the collective bargaining piece, and you know what? Kudos to you for taking that one square on. You went after that one, and I totally appreciate it. Took a lot of courage on your part to hit that one square between the eyes. That was a big problem here, and if the biggest piece of this whole bill to me is that you knocked the collective bargaining piece without hesitation and totally honestly. So look, I hats off to you on that piece. That's a critical piece, but I don't think you're giving yourself enough credit on that for how much of a difference that part alone is going to make. Just that piece alone, by telling because once you do that, the chief, the sheriff, however they got in their office, can no longer hide behind, well, I tried. No, you own that bad officer. You own him. The next time he does anything, you own him, chief. No excuses. You kept him here. And so, and that's critical because, when the political class says, chief, why is he still here? You're out of here. Right now, you can't go to the chief of police in Baltimore City right now and blame him for any of the bad officers that are there. You really can't, because he hasn't got the discretion to get rid of them. But once he has that discretion and he keeps them, his head should roll if he keeps them on. And that's a challenge we face. That will make him answer to the public officials who are saying, why is that officer still on the board or still on the force? And that's all I think if we can get a system that allows public accountability where the people can actually look at that chief and he can't dodge the bullet and say, it was the union, it was the grievance procedure, it was LEOBR, it was whatever. They keep saying this stuff because what they mean when they say that is, I don't have the power. And most of them don't have the power. Give them the power and hold their feet to the fire. And when they keep the bad cop, axe the chief, axe the sheriff. That's all I'm saying.
Great. Excellent dialogue. All right, Senator Bailey, go ahead. The floor is yours.
Thank you. So I will have to say that I do agree, and I think that a hearing board is a big part of a defense when a disciplinary finding is handed down. you should, when they say, yes, this is a sustained hearing and you want a hearing board, right? That is the last ditch effort that an officer has to clear their name. And I think that LEOBR was set up that way on purpose. It was set up that way to give that officer that ability to have due process. And to just say, no, we're not doing that, I think that is completely wrong. And I think we talked about standards and we talked about integrity. And I've heard different people today talk about different roles in life that people have had. But I will have to say, from being a policeman, from living in the house with an attorney, from dealing with attorneys up here and dealing with lobbyists, I've only met one group of people that has to tell the truth every time they open their mouth. And that's a policeman or policewoman. Because if they don't, right, their life and their career is over. And I would just like everybody to look in the mirror and see if you're held to that same standard. Every time that you express yourself, clearly that is not the case with everybody's occupation. And I think that when you're held to that standard publicly, and we do away with things like a hearing board, the ability for a chief to run amok is very quick. I mean, you're going to end up with a bunch of people that are just toy soldiers following the chief around. They're not going to have any opinion. They're not going to have any will to do what they think is the right thing because they know that chief's going to hold their career and their family right in their hand. And that is not what we should be doing. Thanks.
Excellent. Thank you, Senator Bailey. All right, now we'll move on to Jamie. Bring us home. We're almost there. Be good to put a bow on this.
Thank you, Mr. Chairman. So the last page, page 17, is uncodified language. Section 3, which is lines 1 through 9, is the applicability. So the bill's prospective and may not be applied or interpreted to have any effect or application to a collective bargaining agreement that was entered into on or before the effective date of the act. For the duration of the contract term. So this doesn't exclude any extensions, options to extend, renewals of the term of the original contract. The bill also wouldn't have any effect on any, excuse me, any disciplinary matter against a law enforcement officer based on alleged misconduct that occurred before the effective date of the act, if a hearing board had been convened already. So you'd need to meet both of those conditions to be exempted from the bill's provisions. Section 4 deals with correcting obsolete cross-references, and Section 5, which is lines 19 through 23, makes the act an emergency measure.
Excellent. Okay, great. So it looks like we went over about 20 minutes, but the dialogue was so rich that we continued on. I really appreciate this. I thought this was very helpful. So I know everyone's exhausted, but this will pay off in the final analysis when we produce a great product. Senator Carter, I see you. Thank you for hanging in there. I know this was a long day. So look, tomorrow after hearings, no work group. But please do prepare amendments throughout the day so that they're ready for council by the end of business by COB tomorrow. Thursday, Friday, we will vote. And if we're here for dinner, dinner's on me. So we'll send out menus and stuff like that. But so I will talk to you all later. Thank you all for pressing on. This is going to pay off. So I'll see